when the order was placed between Satina and myself for Devin and Sterling, Devin was entitled to support.
Unfortunately, you're misinterpreting it. The fact that there was a court order setting child support at 0, obviously you could have come back anytime after the other child emancipated. Is there a reason based on these circumstances, ma'am, or any legal circumstances, why I should not start the child support on the 1st of June of this year? So at this time, the court's going to go on the record, and this is Bell County cause number 183,698-B. This is in the interest of Ford minor child. Non-custodial party in this matter is Santina A. Valance, and custodial party is Everett M. Ford. Everett D. Ford. And this is before the court on a suit for modification of child support and motion to confirm arrears. Court's taking judicial notice of the court file. Note for the record that both parties. Okay, wow, this one's been around a while, longer than I thought. Looks like there was service citation. Okay, back in May of 2026. On both parties. It appears both parties are present today. This matter did involve one other child, but it appears that child is emancipated out. In other words, is over the age of 18. And Devin is the only child remaining. Anyway, at this time, I'll ask the state for an opening to tell the court what the state's requesting we do here, what you understand agreements and contests to be at this time, and we'll take it from there. Thank you.
Thank you, Your Honor. We're here on a suit for a modification of a support order. It's the state's understanding that both parties are in agreement with support being modified to the following. Guideline child support would be $652 per month beginning September 1st, 2026. Medical support would be $100 per month beginning September 1st, 2026. The only contested issue is that Mr. Ford is asking for retroactive support. The state does not have an interest, and we're asking for the court to make a ruling on this. A timeline is there was an order establishing the parent-child relationship back in February 7th, 2001, where Mr. Ford was ordered to pay child support. And then there was a temporary order back in December 12th, 2013, where there was 2 dependents and child support remained the same and medical support 0. And then we had an order modifying the parent-child relationship back in November 22nd, 2017, where there was split possession. CP had Devin and NCP had Sterling, and child support was set for 0 for both parents.
All right, then, folks. Okay, I'll go ahead and let the state call you both as witnesses. Obviously, under Texas law, I can go back to the date of service for retroactive child support. Is once the party's on notice, that's considered to be the standard. So, like I said, I just looked at it, and it appears both parties are served in May. So that means retro would go back to the 1st of June. Is that correct, Mr. McKinney?
Yes, Your Honor, that is correct.
All right, just wanted to make sure. All right, then, everybody, let's find out what's going on. And again, ma'am and sir, let's say that's the norm. And obviously, the custodial party has the absolute right to ask for that. And the burden of proof would technically fall on the non-custodial party to show why I shouldn't know. But that's the legal jump I can throw you. So at this time, I'm going to ask at this time both of you raise your right hands, and we'll get you both under oath, and we'll take it from there. All right, do you both solemnly swear or affirm the testimony you're going to give here today is the truth, the whole truth, and nothing but the truth will help you?
I do.
Yes.
All right, you're both officially on oath. I'm going to go ahead and let the state call you both as witnesses. At the end of the hearing, if there's anything either of you think I need to know that didn't come out, you'll be allowed to tell the court that information, so long as it's relevant and pertinent to what we're doing here today. You're your own lawyer, so technically you have the right to present a case if you wish. But if you do, I got to hold you to the standards. Is again, like I said this morning, as if you went to Baylor Law, okay? And that means the Texas Family Code, the Texas Rules of Civil Procedure, and the Texas Rules of Evidence will have to be complied with. So at this time, I'm gonna go ahead and let the state call you both as witnesses, and then afterwards, like I said, I'll let y'all tell the court anything else that you think is pertinent and relevant to what each of you are requesting. Thank you. You may proceed at this time, Mr. McKinney.
The state calls Satina Balance.
Yes.
Can you please state your name for the record?
Yes, Satina Balance.
And are you still in agreement with our guideline support being $652 per month beginning September 1st, 2026?
Yes, I am.
And are you still in agreement with medical support being $100 per month beginning September 1st, 2026?
Yes.
And what insurance does the child currently have?
Medicaid.
No further questions for this witness, Your Honor.
All right, ma'am, I'll get back to you in a moment on the issues of the retro, but I'll go ahead and let the state call the father, and we'll get this part wrapped up. Thank you.
The state calls Everett Ford.
Yes,
Can you please state your name for the record?
Everett Ford.
Are you still in agreement with child support being set at $652 per month beginning September 1st, 2026?
Yes,
And are you still in agreement with medical support being set at $100 per month beginning September 1st, 2026?
yes.
No further questions, Your Honor.
All right, I'm just going to start with you, Mr. Ford, because again, it appears to be your request. My understanding is, sir, that you're asking the court to follow with what the Texas Family Code allows and order the child support date instead of starting September the 1st to go to the first date after service, and which in this case would be June the 1st of this year. Is that what you are requesting, sir?
No, Your Honor. I was looking at the Texas Family Code section 154.009 in regards to retroactive support and how retroactive support is arrived. And basically, it states that if there is no one order to pay support during this period of time from a prior suit, that retroactive support is allowed. When the order was placed between Satina and myself for Devin and Sterling, Sterling was under the age of 18, which she was entitled to support, as well as Devin was entitled to support. Sterling emancipated out in 2017, which she was no longer entitled to support at that point, and Devin Ford was still entitled to support. The support wasn't ordered by a court during that period of time.
All right, sorry, sir. Unfortunately, you're misinterpreting it. The fact that there was a court order setting child support at zero, that was the court order. Obviously, you could have come back anytime after the other child emancipated, but this is the first time the courts had an opportunity to hear that after notice and service. So again, under the law, I can only go back until the first day after service, sir. Again, you had the right to do it a lot sooner than this, but that wasn't brought before this court or the district court. And at the time, the other child emancipated, there was a court order, and the court order said $0, even though at that point it was technically no longer appropriate. But until the court ruled on it or something was brought to the court's attention, then again, it was the order of the court. The child support, it was $0 for that time frame, sir.
So it is the judge's standing that at that time it was not appropriate that the order be set at $0.
No, sir. No, sir. So I'm saying that it was set at $0 until somebody brought it to the court's attention or brought it back to the courts to change that child support. And obviously that could have been done in 2017. And here we are, obviously almost 10 years later, and I can't go back for retro that far, sir. Even under normal circumstances, I can only go back 4 years, but still, this is not the normal circumstance. It was a court order. Right.
This child support procedure has been in place for over 2 years now, Your Honor.
All right. Again, Mr. Kenny, again, the handwriting's kind of bad on this service, but I'm seeing the service looks like it was on, both of them were served in May of this year, correct?
Yes, Your Honor.
All right. Again, sir, under your scenario, I can only go back from the date of service. In other words, the time that the other party was aware that you were asking for a change in child support. If it's been sitting for 2 years with no service, then, sir, I can't go back behind that date. I understand you're not a lawyer, but that's the way that sets up. She's entitled to legal notice that you want to change, and the legal notice came in May of this year, not 2 years ago.
We were in court for this prior to May, Your Honor.
You may have been, sir, but I'm looking at the citation again. It's based on the service upon the mother. If she made an okay, let me see. Is there any type of appearance made before that date? Oh wow, there's not even anything in here for 17. The last docket entry in this case is in 2014, and that was 2013, 2014, and that was done when y'all both had attorneys. Looked like Miss Weaver was one, and I can't see who was the other, but that was before the district court. And there's nothing in here that shows that the mother submitted herself to the jurisdiction of the court prior to that, since that date, sir. You saying there was another date that y'all actually appeared before the court?
Yes, Your Honor.
Not appear before the court, sir. I mean, appear like we're doing right now. You would have to sit here and I'd have to call the case, and then both of you would have to appear before the court, and the other party would have to waive service of citation at that point, and I don't see that.
Yes, Your Honor. We both were at a hearing with the OG, the Office of Attorney General, OAG, when there was no settlement at that point. I was contacted.
Was that a child support review order at the Attorney General's office, or was that here in my courtroom, sir?
No, it was in the courtroom, Your Honor.
All right. And when was it? What was the date on that?
I would have to check my records, but it was within the last 12 months.
Okay. Well, again, sir, there's nothing to show that y'all actually came before me. Do you recall coming actually and doing exactly what you're doing now, and both of y'all coming before me? Because that would take that, and it would take the other side making an appearance without citation at that time. Again, sir, I know I'm just throwing a lot of lawyer stuff out at you, but not only if there was not service and everybody just showed up voluntarily, she would still be entitled to service and her 20 days notice before she has to come back in and deal with anything.
Yes, Sean.
Again, my apologies, sir, but obviously you had the opportunity. This could have been changed a while ago. And I see at one time y'all had private counsel, but right now, the Attorney General, this is the first time it looks like it's been before me since 2013. And this is, and I don't see anything else to show something different. And I surely don't see anything that says that the mom has waived service of citation and wish to proceed at that last time that y'all were before me, sir. So like I said, based on that circumstance and the service citation, the earliest I can start the retroactive child support, the new child support amount would be the first day of June of this year. Is that what you're requesting me to do, sir? Go back as far as I can under the law?
Yes, Your Honor.
All right, then. All right. Thank you very much, Mr. Ford. Is there anything? Yeah, I'm going to let the state go ahead and call the mother. I'm going to go. And is there anything else you want to tell me or anything else at this point, sir?
No, there isn't.
All right, Mr. McKinney, we'll come back to Mr. Ford in a moment. Will you call your next witness, please? Thank you.
The state calls Miss Balance.
Yes.
Ma'am, state your full name for the record, please.
Sir?
State your full name for the record.
Oh, Satina Balance.
All right, thank you. You may proceed, Mr. McKinney.
You're asking for support to begin. Sorry, excuse me. Are you asking for support to start September 1st, 26?
Yes.
No further questions for this witness, Your Honor.
All right, ma'am, you've heard me tell Mr. Ford to go through an extensive explanation of how the law normally works under these circumstances. Again, he's entitled to have child support based on the fact that the other child is emancipated and that you were served in May of this year, if you recall being served by the sheriff or constable at that time. Then I can order child support to start the first day of the month that follows that, and that would be June 1. Is there a reason based on these circumstances, ma'am, or any legal circumstances, why I should not start the child support on the 1st of June of this year? I know you're not a lawyer, ma'am, but you represent yourself, so that's the standard. I got to ask you that one.
No, sir.
All right, then. Anything else you want to tell me, ma'am?
No, I don't have anything else to say.
All right, Mr. Ford, is there anything else you want to tell the court before I make my ruling?
No, Your Honor.
All right, Mr. McKinney, anything you'd like to make in a closing statement or at this time, sir?
Yes, Your Honor. We're just asking for the guideline support of $652 per month to begin September 1st, 2026, and the medical support of $100 per month to begin September 1st, 2026. And that is all the state has, Your Honor.
All right, then. Thank you very much, Mr. McKinney. Well, again, folks, since this has obviously been something that should have been taken care of years ago, I'm not even talking about months, I'm talking about years ago. I'm going to go back to the first day after service, Mr. McKinney. I'm going to order child support to start the first day of June 2026. So, ma'am, technically, you're not behind. There's a judgment that you owe that amount, but you're not legally behind on that amount. So, what you have to do, ma'am, is start making your regular child support payments, and try to send them something until it starts coming out of your paycheck or however you get a retirement check, whatever you get, disability check, anything like that. If you need to start making payments on that. Along with a certain amount to help reduce that other amount. If you send in an extra $30, $40 a month, it will take approximately a year and a half to pay that down because there is a 6% interest on that going forward.
And how much is it?
Okay, again, what they like is usually like $50 plus interest, and the
Mhm.
interest and the interest on this would be something like it's $1,000, so it'd be something like $10 a month. Okay, at
Okay.
most. So
So the back.
if you send $60, you're hitting principal and interest easy. All right.
Okay. So just send an extra $60 with it.
Yes, ma'am.
Okay.
Yes, ma'am.
Thank you, sir.
And the other thing is, are you working? Are you employed?
Yes, I am.
All right, but so man, there's a chance the state's going to send a withholding order to your employer. They won't take out the extra amount, but if you notice on the front page of your documents, with the Attorney General's office, there's at the very top, there's the Bell County calls number, but on the left-hand side, there's the OAG number.
Uh-huh.
If you go online and pay that 60, that will go in there. Like you can go online to the Attorney General's office and pay that electronically. You can go to any Walmart or CVS pharmacy and get a MoneyGram, which is technically a Western Union, but they do it, since it's child support, they do it at a discount rate. And as long as you give them that number and give them the money, they will give you an electronic receipt to show that you made that extra payment. Okay.
Okay.
And in 2026, electronic receipts are that's it. Nobody uses money orders or anything like that anymore. So yeah, or even cashier's checks. I once had the Attorney General lose a $10,000 cashier's check from a client. So but now that we do everything online, that's the way we go.
Okay.
All right. All right, Mr. McKinney, I'm going to go ahead and grant the retro, but again, Mr. Ford, that's as far back as I can go. And each of you have the absolute right to de novo what I did. You can go ask the district judge to do something different, but again, based on these circumstances, that's easily fair and equitable because of the time frame it could have been. And of course, you have the right to de novo, but you only have so many days to do it. You have the right to ask the court for a rehearing within the next 31 days. And because I still have jurisdiction, but after I signed the order, 30 days after I signed the order, nobody, if you wait till after that, no judge in Bell County has jurisdiction any longer. You got to go down and see the Third Court of Appeals in Austin, Texas, to get any type of jurisdiction after that. So you got 30. So each of you actually have the right to go talk to a lawyer and get something done within the next 30 days if you feel this was an inappropriate order. All right.
Okay.
Yes, John.
All right. Thank you. Thank you very much. I'm going to have the state prepare that. You want them back and break out the review and sign off on that, Mr. McKinney, or you going to let them go?
Yes, Your Honor. I want them put back in breakout rooms while I draft the order real quick.
All right, folks. The state's going to go ahead and draft the order and get it to you, and then they'll send it to me by either DocuSign or e-file, and then I'll sign off on it, and that'll start the clock running. Good luck to both of you and the child, and everybody take care out there. Thank you. We're off the record.
Thank you.
Thank you, Your Honor.